Yes, welcome to our discussion on the principles of South African criminal law. It is essential for a prosecutor, a defense lawyer, a judge, or an ordinary citizen of the Republic to have a basic knowledge of the principles of criminal law. So, on that note, we are going to spend time just to discuss some of these issues, to unveil some of these principles so that you can be adequately informed about them and be able to make informed choices and decisions. Thinking in terms of criminal law, let us just go on quickly to look at the sources of criminal law. We have legislation, which is sometimes called statutory law. Then we have the common law, and we have the Constitution of the Republic. They serve as very important sources of criminal law. For instance, legislation is those acts of parliament that regulate different conduct. An ordinary, maybe act of parliament, such as the Firearms Control Act, obviously places conditions regarding acquisition of firearm licenses, who can use a firearm under what circumstances. Even very, you know, even statutes that may seem unrelated to criminal law, for instance, the Road Traffic Act, which then goes on to impose conditions upon which one may acquire or use a motor vehicle, placing requirements on acquisition of licenses, driver's licenses, and vehicle licenses, and all necessary conditions that one must meet in order to make use of a motor vehicle. They tend to impact on criminal law without us noticing. And then, of course, we have got the Criminal Procedure Act 51 of 1977, serving as a very, very important statute in connection with, criminal law in South Africa. There are many other statutes that go on to create offenses in terms of maybe prohibiting certain action and stipulating that failure to observe certain regulations may result in a criminal conviction, even stipulating the sentence, the penal provisions, rather by stipulating penal provisions to say what punishment one must be given for violating any of the rules that may be set therein. And then there is the common law, which refers to the principles of law that have been, received into the South African legal system from ancient Rome, the Roman Empire, and how the development of certain rules and laws there have actually impacted the development of South African law. Many other jurisdictions in Southern Africa, for instance, Botswana and Zimbabwe, happen to also use or apply the same principles of Roman Dutch law. So these common law principles which have been applied by court, and knowledge about them is available through the precedent system, that is the stare decisis principle. You find that conduct to do with, say, theft of another person's property is actually a common law crime. So is murder, and so is rape, as well as assault. So you find that such conduct is stipulated as a criminal offense or offenses, and then it even defines, what requirements must be satisfied in order for a successful conviction to take place. So that's as far as the common law, that is the Roman Dutch common law, is concerned. And then the Constitution also spells out some very important principles, as one you would see in Section 35 of the South African Constitution, which talks about such principles, and as presumption of innocence, and of course, it introduces and enshrines the right to, you know, the right to remain silent, and all those warnings that the police must give to a person as they are being arrested for whatever they are a crime they are suspected of having committed, and so on. So the Constitution does play a very significant role in determining some of the rules and the principles of criminal law, of course, as well as criminal procedure and principles of evidence. It is very important for us, just as a point of departure, to explain what we mean by criminal law. Criminal law falls into that branch of public law which deals with the punishment of persons for committing acts which are harmful to society at large. So it is in terms of criminal law that wrongs perpetrated against the interests of the state are punished, because the state is always seized with the responsibility to maintain order, public safety, and public peace. So take, for instance, a person who murders or who commits an act of murder. In order to avoid self-help by friends and relatives of the victim of the murder, the state then steps in and punishes the perpetrator, just so as to avoid this self-help. So we are saying basically the state intervenes in matters occurring between individuals. We've already given examples of theft, rape, murder, so as to prevent that self-help, the self-help responses from the aggrieved parties. Criminal law is distinguishable, of course, from the law of delict, taking into account that the law of delict deals with injuries inflicted by private persons on others. For instance, a person who maybe causes damage to property belonging to another may be punished in terms of criminal law for causing that damage, and at the same time the owner of the property that has been damaged is entitled to a remedy by way of, you know, demanding or claiming damages against the person causing the injury. So, but the difference, of course, is that crimes are actually perceived by this law as you know, acts against the state, and therefore they are punished by the state through criminal prosecution procedures, whilst the delicts are private injuries. In fact, they are redressed between private individuals through civil action, because, for instance, arson, that is destruction of another person's property, it may actually generate conflict which will have public law implications, but at the same time it is a private matter, because the person whose property was destroyed still requires compensation for that. So you find that sometimes there's an overlap between criminal conduct as well as delictual conduct rather. And so for a prosecutor or a defense lawyer, it is always important to draw that distinction between delictual conduct as well as criminal conduct. In certain instances, you find that private prosecutions do take place in adherence to proper procedures, that is in terms of the Criminal Procedure Act 51 of 1977. You find that people only resort to private prosecutions when the state, through the National Prosecuting Authority, for one reason or another fails to prosecute the crime. Then private individuals who are aggrieved by you know, the conduct then decide at their own instance to carry out a prosecution. But of course, because the duty to public, the duty to prosecute lies squarely within the state, it goes without saying that in order for a for a private prosecution to take place, the state must first of all issue a certificate which is called a certificate of nolle prosequi, whereby the state clearly indicates that it is not going to prosecute a particular crime or offense. that has been committed. So for one reason or another, it cannot prosecute, and therefore it then authorizes and permits private individuals to prosecute that case. And when a conviction is secured, that person who has undergone a private prosecution as the accused still goes to prison as any other person prosecuted by the state. So it's very important to take note of that. Another very important point that we need to understand is that the onus of proof in criminal matters lies with the state, or in the case of a private prosecution, it lies with the prosecution or the prosecutor. And what do we mean by the onus of proof? By onus of proof, we are referring to the duty or the responsibility or the burden placed upon the party in a lawsuit to prove the facts alleged. It is the burden placed on the party in the legal battle to provide that proof in respect of the specific facts. For instance, let's take an example of a prosecution whereby the state brings Mr. X or Mrs. Y before the courts, accusing the person of committing a certain act of conduct. You must understand that the accused does not have a duty to prove anything, because remember, he who alleges must prove. So it is the state which makes an allegation that a certain person has committed an offense. So therefore, it is the duty of the state or the responsibility of the state or the prosecution to prove that indeed a crime has been committed by the accused. So we are saying then that the onus of proof in criminal cases lies upon the state, which must prove beyond reasonable doubt that the accused has actually committed the offense being complained of. Because there's always a presumption in favor of the accused in terms of section 35(3)(h). Hence, an accused person does not have to prove anything, and it is therefore the burden is therefore upon the state. And the standard of proof in criminal matters, as I have already highlighted, is proof beyond reasonable doubt. We are going to look at this, the meaning of this proof beyond reasonable doubt standard when we look at the principles of the law of evidence. At the moment, it is sufficient just for you to know that the standard of proof that is required in criminal cases is proof beyond reasonable doubt. And of course, to take note and remember that the burden to prove does not lie with the accused, but it lies with the state, or it lies with the prosecution or the prosecutor. That's why it is possible for the accused just to be arraigned before the court and remain silent and still not be convicted. Because remember, in the first place, the accused was not before the courts to prove anything. But those who are arraigning the accused before the courts must then justify why they have brought that accused before the court by way of providing that proof, that evidence of property value, to convince the court and establish the argument that the accused has indeed committed the offense with which he or she is being charged. A very important principle that we must take note of before we can even, look at the elements of a crime and, elements that are essential for liability in criminal law. One must remember the principle of legality, which is very foundational. The principle of legality simply means a person should not be charged or convicted of an offense which does not exist in law, the prosecution must be subject to the principle that principle of legality, which rather presupposes that certain facts are already in existence. For instance, number one, the court cannot create a crime, and a conviction should only be based on an already recognized act by law as a crime. That is a principle called, rather known as jus acceptum. We are saying here that the prosecutor cannot and must not just bring somebody before the courts and charge them on an offense that does not exist according to the law, whether it be statutory law, whether it be communal law. If there is no such offense, if the conduct being complained of is not regarded in any of the sources of law as a crime, then a prosecution should not be undertaken. And even if it is, the court must not convict, must not find the accused person guilty, because in the first place there was no such crime. And number two, the act being prosecuted must already be recognized as a crime at the time of its commission by the accused. In other words, if the law comes into effect today to say that a certain act should from now on be punishable, it then means that a person who committed that act yesterday or last year should not be convicted, because at the time of the commission of the act, it was not deemed a criminal offense in terms of the law at the time. So the principle simply says that the law doesn't operate with retrospective effect. In other words, you cannot punish somebody today for an act that they committed sometime in the past before the law had come into effect. Basically, then, whatever law is put in place applies from the day of its commencement moving forward, which means if a law is if a law is enacted today, it can only apply as from today and tomorrow and moving forward. So that's how this principle of jus praeviam actually operates. And then the third principle is that crimes ought to be formulated clearly and not vaguely. In other words, you see, if a law does not clearly define a particular act which is deemed to be a criminal offense, then it is prejudicial to the people. And the most important principle is that when the legislature formulates the law and creates crimes, then it must do so very clearly and not in vague terms. That is the principle of jus certum. It must be certain. In other words, a person reading the statute must get certainty, clarity from what is being communicated. It must not be left guessing. It must not be ambiguous. It must not be subject to multiple interpretations by different people. And we are saying a court must interpret the definition of the crime narrowly rather than broadly. So it so happens sometimes that a statute it defines a certain conduct as a crime, and then a person is brought before the courts, arraigned and prosecuted, and then it turns out that in terms of that the formulation of the crime, it could cover so many acts or conduct. So the principle of jus strictum then says that the crime must be narrowly, defined or circumscribed, so that only specific conduct that conforms as clearly as possible with the prohibited act must be punished. It mustn't be too broad. And then, last but not least, it's very important to note that A court can only impose a sentence that is already legally recognized. In other words, if a statute, for instance, had said that driving between 6 p.m. and 9 p.m., just for argument's sake, will attract a fine of, let's say, 200 rands. And if suppose that had always been the prescribed fine, and then it so happens that the parliament revises that penalty, say, to 500 rands, and it so happens that whilst the case is still going on, of maybe somebody had been arrested for violating that rule, and then there is a change in the penalty from 200 to 500 rand. It is very important that the court may only impose the penalty that was already in existence at the time of the commission of the offense. It cannot then go on to apply the newly adopted or newly imposed fine or sentence, if one could say. So if you look at this one, it almost operates on the same basis and along the same lines as the jus praevium, or the principle that one cannot be convicted of a crime that did not exist at the time. So it is on the same note, one cannot be sentenced or punished in terms of a punishment that did not exist at the time of the commission of the offense, even if the crime had already existed and defined. But if there is a change in the penal provision, then it must always be the new one that, in fact, it must be the one that applied at the date of the commission of the offense, rather than adopting the new penal. But if it happens that the figure is now, the penalty is maybe being reduced from 200 to 100, then in a way the accused must benefit from the change, because then it means that the latest is now of benefit to the accused in a way. Now, having spoken about all these different aspects up above, whereby we have looked at the principles of what is criminal law, and then the issues of the onus of proof, and then the principle of legality, our next step is to look at the elements of criminal liability, whereby we are going to be defining what we mean by an act or a conduct in criminal law. And then we are also going to be looking at causation and the compliance with the definitional elements of a crime. Of course, looking at the distinction between formally defined crimes and materially defined crimes. And then we will look at the element of unlawfulness. We'll look at culpability, whereby we are looking at intention as well as negligence. And you know, culpability is quite a broad topic. Intention itself is going to preoccupy us for quite a while, and so is negligence, measured in terms of our reasonable men test, and so on and so forth. But that is going to be covered in our next, or rather some of our lectures that we are going to hold. So in the meantime, take note that the elements of criminal liability are act or conduct, compliance with the definitional elements, and then unlawfulness and culpability. Now, to conclude our discussion, this lecture has identified elements necessary to establish criminal liability. It defined criminal law and distinguished crime from delict, and then it explored the meaning of the concept, of the concept of legality, and it identified the elements of liability, namely an act or human conduct which complies with definitional elements of a crime, and then just highlighting that unlawfulness and culpability are very essential elements of liability. Now look out for our next videos on the individual elements that constitute criminal liability. Thank you very much for taking part, rather for listening to this, watching this video to the end. Please just remember to subscribe to my channel and to share the channel with your friends. Enjoy your day. Bye bye.